But we begin at this hour with a big decision that just came down from the Supreme Court, in which the Supreme Court has decided without any evidence, without really any support, that Title VII of the Civil Rights Act now protects on the basis of sexual orientation and gender identity, which is relatively insane because Title VII obviously did not mean, and the court acknowledges this, did not mean to deal with gay and lesbian issues or transgender issues. The notion of gender identity was not even familiar to people in 1964 when the Congress of the United States was passing Title VII, which prohibits any sort of discrimination on a federal level on the basis of race, color, religion, sex, and national origin. Now, the Supreme Court is making the absurd contention that Title VII of the Civil Rights Act prohibits discrimination on the basis of sexual orientation, which, by the way, people knew that folks were gay and lesbian in 1964. They did not include that in Title VII. Not only that, but Congress has repeatedly attempted to and failed to include sexual orientation in updates of Title VII. They failed because that's pretty controversial stuff. I mean, that's talking about, for example, you're a Catholic hospital, and now you are mandated to violate your own religious precepts in hiring gays and lesbians or transgender people. Right? This is something that the Democratic Party has been pushing for a very long time, but it's a controversial issue because it is not included in Title VII. Title VII was meant to say that if you are a woman, that you cannot be prohibited against on the sole basis that you are a woman. Not that you are a gay woman, for example. Not that you are a gay man, but on the basis that you are a man, you cannot be discriminated against. And on the basis that you are a woman, you cannot be discriminated against. Well, now the Supreme Court has gone back in time and magically course corrected to include sexual orientation and transgender identity in federal civil rights legislation that obviously was not meant to be there. So now the idea is that if Bob walks into your place of employment tomorrow, and you're a large company, you have over 50 employees, Bob walks into your place of employ tomorrow, and he says, "My name is Gene. I wish you to call me Gene." You say, "Well, Bob, that doesn't really fit your job description. And that's not something that we're ideologically okay with here. You're now in violation of federal civil rights law," right? That is the idea under this decision. Now, there may or may not be an exception for openly religious organizations. So not Catholic hospitals, which do a secular business, or Catholic adoption agencies, which do a secular business, but you work for a church or you work for a Catholic school, right? That may be part of the job description, is that you abide by Catholic doctrine or Catholic teachings. But for example, there are a lot of Catholic schools that have sort of religious studies in the morning and then they have secular studies in the afternoon. But they also do not want people in the afternoon courses who may not be Catholic, for example, to be openly violating certain religious precepts. And so they say, listen, we teach at the school that certain types of human activity are sinful and we don't want our teachers engaged in that. Theoretically, that could now be illegal. If you have if you're a religious person and you own a corporation, you say, listen, people who work at my corporation, I just don't want them participating in certain types of activity that I don't like. Well, now that would be the basis for a lawsuit. What is left completely unclear here is whether it is the basis for a lawsuit, whether, let's say, you abide by this new ruling and a transgender person comes in, you hire the transgender person, but you are a conservative company and you say, as I do and as Daily Wire has said, that a man is a man and a woman is a woman. Does that now amount to discrimination under federal law? It is not clear under this particular provision of the Supreme Court decision. So this is a very far-reaching decision. It's a very bad decision. And the part of it that's quite shocking is that Justice Gorsuch wrote the decision. Now, if you listen to the oral arguments way back in February, it was pretty obvious which way Gorsuch was going to go on this thing. It was pretty obvious always where Roberts was going to go because Roberts is a garbage justice. But Gorsuch was widely perceived to be a textualist. His attempt to shoehorn textualism into this decision is insane. I mean, it's really wild because the fact is that what a textualist would do, or an originalist, is they would read the text of the statute and look at the meaning of the statute at the time and say what it meant or what it did not mean. They would not say, oh yes, we've updated the wording now, so now it means something completely different than what it meant back in 1964. But that's exactly what Gorsuch does here. So Gorsuch says, we agree that homosexuality and transgender status are distinct concepts from sex. Okay, that should be the end of the inquiry, right? Once you say that homosexuality and transgender status are not sex, right? That's a completely different concept. Then you have to make the argument that presumably the Civil Rights Act of 1964 talks about discrimination on the basis of sex, not on the basis of homosexuality or transgender status or sexual orientation or any of that. Right? But, says Gorsuch, as we've seen, discrimination based on homosexuality or transgender status necessarily entails discrimination based on sex. The first cannot happen without the second. Nor is there any such thing as a canon of donut holes in which Congress's failure to speak directly to a specific case that falls within a more general statutory rule creates a tacit exception. Okay, that's not true at all. Okay, if it is perfectly obvious that Congress has repeatedly attempted to fill a donut and that the donut has not been filled, then it's pretty obvious that Congress itself perceived that the donut had not been filled. In other words, it's not that Congress created this overarching penumbra and emanation that the Supreme Court was supposed to fill in. The idea instead was that Congress was being very specific about what it wished to prohibit. You have a job. All you know about the applicants is that one is a man and one is a woman. You cannot discriminate solely on the basis of sex, right? You cannot discriminate on the basis of sex in that decision. Now, as Justice Alito points out in his dissent, it doesn't make any logical sense what Gorsuch and the majority do here, right? So Gorsuch says sexual harassment is conceptually distinct from sex discrimination, but it can fall within Title VII sweep. Would the employers have us reverse those cases on the theory that Congress could have spoken to those problems more specifically? Of course not. As enacted, Title VII prohibits all forms of discrimination because of sex, however they may manifest themselves, or whatever other labels might attach to them. So in other words, what he is saying is that sexual orientation is covered by the prohibition to discriminate on the basis of sex because you couldn't be homosexual without being a member of the same sex as the person to whom you are engaging in sex, right? So in other words, if a woman has sex with a man and is not fired, but a man has sex with a man and is fired, it is not sexual orientation that is the question, but the sex of the man. But as Justice Alito points out, that makes no sense because you could very easily have a policy that says a woman cannot have sex with a woman and a man cannot have sex with a man. Again, by the way, this is not to make the case that people should not hire gay men or gay women. This is me talking about whether you are forced by law to hire people, right? Whether you are forced by law. That is a different question as to what I would do in a business circumstance. I'm sure there are people who are gay and lesbian who are working for my company right now. I don't care. And frankly, if somebody applied as a transgender person, I wouldn't care about that either. Okay, the reality is that I'll hire anybody of any time so long as they can do the job. I really don't care. But that is not the question here. The question is whether the federal government can compel businesses to violate freedom of association, to violate freedom of religious liberty, to violate freedom of speech. And you watch, this decision, ironically enough, will then be used as a social media club with which to beat everyone who says things like men and women exist. So a decision which basically says that anything that manifests manhood or womanhood is now violative of federal law if you fire somebody on that basis or discriminate on that basis. That will be used as a cause by social media within the next 6 months, watch, to say that if you say a man is a man and a woman is a woman, you are now discriminating on the basis of transgender identity, which ironically enough is rejected by the court here. Because what the court is actually saying is that it is a discrimination against a man if you fire him on the basis of transgender identity. So a man comes in dressed as a woman and you say to him, well, you're not a woman, so I'm firing you. That is a discrimination based on sex, according to the Supreme Court of the United States, okay, which overtly rejects, that implicitly and overtly rejects the idea that a man who comes in and says that he is a woman is actually a woman, right? Because then it wouldn't be discrimination on the basis of sex. It would be discrimination on the basis of something else. So logically speaking, there are a lot of holes in this argument. As Alito makes clear in his dissent, it is unclear what the ramifications of the Supreme Court decision today are going to be. It really is not particularly clear. What is clear is that if you're a religious person in the United States and you own a company, then this is a very big problem for you if you actually hope to use any sort of religious values, traditional religious values in your hiring, right? There is something called the Hobby Lobby case. It held that a closely held corporation like Hobby Lobby could not provide for abortion care in its healthcare coverage, right? So now, under this Supreme Court decision, could a closely held religious corporation say, listen, we don't employ gays and lesbians because we're a religious Christian family and we don't want to do that? Or could they say, we don't want to employ people who are transgender because it violates our perspective on what males and females are? Right? All of that is left up in the air by this decision. Also left up in the air is what does discrimination constitute? So as I say, I'll hire anybody at my company, but I will say on the air that a man is a man and a woman is a woman. Well, let's say I say that just around the office. Let's say I'm talking to some people around the office and I'm talking politics and I say a man is a man and a woman is a woman and a transgender person overhears that. Have I now created a discriminatory work environment? Utterly unclear from this decision. Utterly unclear from this decision. So the decision creates an enormous number of questions. It is legally ridiculous. Not only is it legally ridiculous, it does give the lie to the idea that conservatives can simply rely on the federal courts of the United States to protect them. And this has been one of the great lies that conservatives have pushed for years. All we need to do in Congress is give you tax cuts and judges, and then you should be happy with that. Okay, two of the judges who voted for this very, very bad decision on a legal basis, two of those judges are Republicans. Two of those were appointed by Republicans, Roberts and Gorsuch. Right, there are only 4 Democratic appointees who voted for this decision. This thing went 6-3. So once again, Republicans proving themselves incompetent at selecting Supreme Court judges. I'm old enough to remember when But Gorsuch was the big excuse for you have to back Trump because But Gorsuch. Gorsuch was the opinion writer in this particular case. By the way, worth noting, this is the same Supreme Court that has turned down multiple Writs of certiorari, writs of cert are applications for a Supreme Court case on the Second Amendment. So the Supreme Court will not decide. Basically, the Supreme Court has established a federal right for you to own a gun in your home, but the Supreme Court has not decided whether you can carry, whether you can have a gun at your business, and they've rejected every case on that basis. Second Amendment cases, they're rejecting right and left, but they certainly took up a case in which they basically established that if you fire somebody on the basis of your own religious conviction and you're not an overtly religious organization, then you can be federally sued under the Federal Civil Rights Act of 1964 without any additional legislation, even though it is clear to everyone, right, left, and center, that the 64 Civil Rights Act did not cover this sort of activity. It obviously did not. Okay, this is perfectly clear. Gorsuch admits as much. He just expands it. Okay, that's bad law, and it's once again proof that if you're relying on judges to save you from the elements of the left, good luck. Good luck. It ain't going to happen. I hope you enjoyed that clip from The Ben Shapiro Show. If you did, go ahead and hit the subscribe button so you stay up to date on all of our future content.